Welcome, I am Sarah de Carvalho, CEO of It's a Penalty. Thank you all for joining us today as we launch our research report, CommonProtect, a review of the legal systems protecting children from sexual exploitation and abuse across the Commonwealth. Before we get started, I'd like to introduce you to everyone who will be speaking during today's 60-minute event. Firstly, we will hear from Carolina Henriquez-Schmitz, Director of TrustLaw. Then we are delighted to have a special address from the Right Honourable Patricia Scotland QC, Secretary General of the Commonwealth. It's a Penalty's Advocacy Director, Elizabeth Speller, will then present the key findings from our report. Following on, we will hear from our distinguished panellists, who include Brian Speers, President of the Commonwealth Lawyers Association. Welcome, Brian.
Thank you. Nice to be here, Sarah.
Maria José Castello Branco, who's the Vice Chair of the Lanzarote Committee in the Council of Europe. Welcome, Maria.
Thank you very much, Elizabeth. It's really a pleasure being with you today. Thank you.
Fabakary Jammeh, who's the Practice Director at Sunu Law Chambers in the Gambia. Welcome, Fabakary.
Thank you very much. It's a pleasure to be here.
Musenge Leah Nkonde, who's the Associate at Mwishi Banda and Associates in Zambia. Welcome, Musenge.
Thanks, Sarah. Nice to be here. It's an honor.
And Hasan Irfan Khan, who's a senior partner at Irfan & Irfan in Pakistan and is also a CLA council member. Welcome, Hasan. And finally, we have Dr Letnie F, who's a retired senior lecturer in social work at the University of the West Indies in Barbados. Welcome, Letnie.
Thank you, Sarah. Delighted to be here.
We are honoured to be joined by all of you today. The sexual exploitation and abuse of children is a threat from which no child, community or country is immune. Estimates show that worldwide, 1 in 8 children are sexually exploited or abused before the age of 18. And globally, 1/3 of detected human trafficking survivors are children. Despite significant work being done by governments and the global child protection community to tackle child sexual exploitation and abuse, known as CSEA, millions of children across the Commonwealth remain at significant risk. It's a Penalty has launched CommonProtect because we believe that children all over the Commonwealth deserve to be better protected. We hope that this report serves as a springboard for Commonwealth attention and common action. The report's findings show that there is still a long way to go towards ensuring that every child in the Commonwealth is safe from exploitation and abuse, and that offenders are prosecuted and survivors have access to justice. We're incredibly grateful to all of our partners who over the last 2 years have made this CommonProtect research possible. In particular, special thanks are owed to the Thomson Reuters Foundation and its TrustLaw program, CMS and Clayton Utz, the Commonwealth Lawyers Association and SISTOC. The report couldn't have been produced without the lawyers and researchers in 21 countries across the Commonwealth who worked with us to research and write the country reports. We're also extremely grateful to the contributors of the spotlight pieces, which are featured in the full report, including the Lanzarote Committee Secretariat, the Commonwealth Human Rights Initiative and Walk Free, the Commonwealth Organisation for Social Work, ECPAT International, Human Dignity Trust, ICMEC, the International Federation for Red Cross and Red Crescent Societies, We Protect Global Alliance, Dr. Michael Salter, and UNICEF UK. Now let's hear from Carolina Henriquez-Schmitz, Director of TrustLaw. Carolina.
Thank you so much, Sarah. Hi, everyone. Good morning, afternoon, evening, depending on where you're joining from. On behalf of the Thomson Reuters Foundation, I'd like to first thank Sarah and the It's a Penalty team for inviting me to participate today and share a little bit about our work and the research being launched today. It's a real honor to be joining and to be able to recognize the hard work that It's a Penalty and so many of the partners you've listed, Sarah, have put into this research and the roadmap ahead. For some context, we are the corporate foundation of Thomson Reuters, and we combine our unique expertise in journalism and law to advance media freedom, foster inclusive economies, and promote human rights. As Sarah mentioned, I oversee our TrustLaw program, the world's largest pro bono legal network, through which we connect leading law firms and legal teams across the globe with NGOs and social enterprises that are working to create lasting social and environmental change, like It's a Penalty. Through our TrustLaw service, more than 100,000 lawyers offer their time and expertise free of charge to help thousands of high-impact organizations achieve their social mission and drive critical legal and policy reform. Ending child sexual exploitation and abuse is one of the most urgent issues of our time. It's not only close to my heart, but of notable importance to the Thomson Reuters Foundation, where we've long supported organizations across the world to advance women's and children's rights. I'm sure it goes without saying, but it bears emphasizing that sexual exploitation and abuse of children is taking place at unprecedented levels across the globe. And it's only being exacerbated by the growing digital connectivity and by the widespread impacts of the COVID-19 pandemic. And yet, despite the scale of this atrocious problem, legislation and enforcement mechanisms have simply not kept pace and are leaving children deeply vulnerable. By way of example, earlier this year, we facilitated some additional research for Equality Now, which examined the scope of and gaps in international, regional, national legal frameworks relating to online sexual exploitation and abuse. The research also considered the role of online and digital rights and the role that they play in the protection from and perpetuation of this online sexual exploitation and abuse in a number of countries, including Kenya, Nigeria, India, the US, the EU. The findings were perhaps not shocking, but certainly disheartening. Our laws leave children, adolescent girls, and women at great risk of online sexual exploitation and abuse, often not even contemplating the myriad ways in which the abuse takes place nowadays. Equality Now is using this research to build on its discussions with key stakeholders and produce a set of recommendations for developing international standards that can then inform national laws and responses to protect women and girls in the online space. So very, very much work remains to be done, which makes us especially pleased to have facilitated pro bono legal assistance for It's a Penalty on this multi-country research by connecting them with in-country lawyers at more than 10 law firms across the globe. I hope the research will be a valuable tool for It's a Penalty and partners to build its ongoing advocacy efforts and to help enforce comprehensive and effective legislation on protecting children from sexual exploitation and abuse. And before I turn it back to Sarah, I'd like to just take a moment to express our deep gratitude to our legal partners for their extraordinary work and dedication to this project. We wouldn't be able to do what we do without them and their generosity. With special thanks to law firm CMS and Clayton Utz for their superb international coordination, and again to CLA for their vital partnership. And many thanks again to It's a Penalty for your tremendous and critical work on preventing child exploitation and human trafficking worldwide. We're honored to be your partner and very much look forward to today's panel discussion and the important work ahead. Looking forward to additional collaborations. Thank you again.
Thank you, Carolina. We are so grateful for your partnership, and we couldn't have produced this important report without you. I'm now delighted to introduce the Right Honourable Patricia Scotland QC, Secretary General of the Commonwealth, who has an important address for us all.
Distinguished guests, ladies and gentlemen, firstly, let me thank the Commonwealth Lawyers Association and It's a Penalty for the strong interest and commitment to protect children from sexual exploitation and abuse across the Commonwealth. It is my pleasure to address you during the launch of the CommonProtect report. This report highlights the need of our Commonwealth family to strengthen the legal framework to combat child exploitation and abuse that our member states have adopted. It is also a sad day. Today, we acknowledge that despite the effort put in place by different actors such as parents, governments, academics, civil society, and media to protect young people from sexual exploitation, we are still lagging. What is emerging across the Commonwealth is a catalogue of serious systemic abuse by those who believe they are above the law. The COVID-19 pandemic has exacerbated the situation, with schools closed and many children spending more time at home than usual. There was an increase in reported cases of child abuse during the pandemic. That is not only sad, but also disturbing, because we must seek truth and justice for our children's safety and protection. The truth is that we need to do more, far more, than reform the legal system. The uniqueness of the Commonwealth is that as we seek to undertake legal reforms to assist justice system to tackle sexual exploitation and abuse, we also need to innovate tools to assist our ministers of health, education, sports, and gender to handle similar problems. My experience as a UK Minister of Justice responsible for reforms in the criminal justice system was eye-opening and informative. What we discovered at the time is that how a child develops by the age of 22 months will be likely to determine what they will achieve by the age of 22 years. As ministers, we crafted a plan to reform programs including childcare, teenage after-school programs, and support initiatives for young adults. In effect, our effort and innovation allowed millions of young people to grow up without going through the criminal justice system due to actions that paid attention to children. Our efforts must be direct and robust to target children at a very young age up to when they are developed to whole adults. Technology has also come up with a new challenge for our young people. Most of our children have access to the internet. There are those who are now targeting to abuse children through social media platforms. This is indeed a dangerous trend that has witnessed a rise of children who need protection. By combining our advocacy role, the Commonwealth Lawyers Association and the Secretariat can play a pivotal role in advocating for safe Commonwealth for our young people, including children and girls who are the most vulnerable. Our role as a Secretariat to provide an equal platform for 54 states to agree on serious matters based on consensus cannot be understated. The Commonwealth is a great example of what multilateralism can achieve. 2.6 billion people coming together with common goals and similar vision. 60% are young people under the age of 30. 32 out of 42 small states are part of the Commonwealth. It is our diversity, unity, shared history, common law linkages and purpose to achieve the Commonwealth values is what has made us much stronger. When I became Secretary General of the Commonwealth in 2016, I felt compelled to dedicate my work to the most vulnerable people across the Commonwealth who are faced with gender-based violence. Since then, I have led initiatives with the objective of protecting children and young people from exploitation. I can share a few initiatives that are close to my heart. The Commonwealth Says No More is an initiative to bring together the Secretariat and the No More Foundation. Our purpose is to prevent domestic and sexual violence, deliver grassroots projects, train community leaders, and provide awareness resources. Through this initiative, our member states have been able to access toolkits on prevention of domestic violence and sexual violence through campaigns and advocacy. The Secretariat, through its Sports for Development section, with support from the Rule of Law section, is also working on the development of position of trust model legislation to help safeguard children. This work is being carried out in partnership with UNICEF UK and DLA Piper UK and aims to strengthen the position of trust legislation in Commonwealth countries. These two initiatives are part of the efforts to work together in a multi-sectorial approach to achieve one common goal: to protect our children from sexual exploitation and abuse. My challenge to the Secretariat and our partners today is to see how we can plug and play this report that we are launching to deliver greater success to protect our children. How can this report be a toolkit for our members to utilise as a model to draft better legislation or develop safer programmes for our children? As Secretary General of the Commonwealth, I committed to serve 54 states to fulfil the mandate of the heads of states and the Commonwealth Charter. Our Commonwealth is committed to a world where young people can thrive, sexual exploitation and abuse hinders growth of children. If not us, who? And if not now, when? So I thank you for everything that you have already done and all that you will do to make our children safer and more loved. Thank you.
Thank you so much. We are very grateful and excited to have the support of the Secretary General and the Commonwealth Secretariat. I'm now pleased to introduce my colleague, Elizabeth Speller, Advocacy Director for It's a Penalty, who has dedicated the last 2 years to producing this report with the incredible support of Helen Jones, It's a Penalty's Commonwealth Advocacy Advisor. Welcome, Beth. Before we hear about the findings, could you share some background to the report and how it was produced?
Of course. Since 2020, we've been developing and working on this report, which forms part of the evidence base for It's a Penalty's CommonProtect programme, addressing the protection of abuse and of children from sexual exploitation and abuse in the Commonwealth. The countries studied in the report are 21 Commonwealth member states, spread across 4 regions: Africa, the Americas, Asia, and the Pacific. With help from TrustLaw, the Commonwealth Lawyers Association, CMS, and Clayton Utz, we connected with lawyers and researchers in each focus country to assist with the research. For each country, we examined the prevalence and profile of CSEA, the gaps and successes in the legislation or criminalisation of these offences, prosecution, protection, and prevention systems. From this analysis, we made recommendations for the advancement of child protection in each country and Commonwealth-wide.
Thanks, Beth. So according to the report's findings, what does child sexual exploitation and abuse look like in the Commonwealth?
Child sexual exploitation and abuse takes place, unfortunately, in every Commonwealth country in every form. Throughout the 21 Commonwealth countries that we studied in this report, we identified a number of Commonwealth-wide trends that are present in each country and risk factors which increase children's vulnerability to abuse. In every country studied, familial abuse and abuse by perpetrators known to the child are very common. This form of abuse has further repercussions, of course, as children often feel unable to tell anyone that they have been abused by someone that they know out of fear of backlash or not being believed. In many countries studied in the report, a culture of silence about CSEA exists, along with societal stigma and victim blaming that results in survivors not reporting or disclosing what has happened to them. Furthermore, pervasive gender norms in many Commonwealth countries increase gender-based violence and silence male survivors. As many Commonwealth countries rely significantly on tourism in their economy, the sexual exploitation of children in travel and tourism settings is widespread, as is the trafficking of children for sexual exploitation and forced labour. We found that harmful traditional practices, including child marriage, female genital mutilation or FGM, and witchcraft are present throughout the Commonwealth. And many of these practices can be considered pathways to the sexual exploitation and abuse of children. Further risk factors which are present in the majority of countries studied include widespread poverty, HIV/AIDS prevalence, growing accessibility to technology, including the increase of online child sexual exploitation and abuse, and distribution of child sexual abuse material or CSAM online. Climate-related disasters, conflict and displacement also result in large refugee and migrant populations.
Thank you for sharing those findings. This is obviously a very significant area of concern in the Commonwealth. So what does research tell us about the key gaps in the criminalisation of child sexual exploitation and abuse in the Commonwealth countries?
The research highlights several gaps in the criminalisation of CSEA offences. What came through very strongly was the issue of definitions. Many countries lack a broad definition which criminalises all forms of exploitation and abuse, including grooming, sexual exploitation, sexual contact, or abuse in positions of power over a child. Furthermore, we found that 10 of the countries studied do not clearly define a child as under the age of 18. In some countries, the definition of a child is very low, meaning that children as young as 11 may be treated as adults under the law. In other countries, the definition of a child varies throughout the law, leading to inconsistencies in its application. Importantly, in some countries, the age of consent is also not clearly defined. This means that children are left vulnerable to CSEA. In many Commonwealth countries, a close-in-aged offence has also not been enacted, and therefore children engaging in consensual sexual activity with each other are at risk of being criminalised. We found that outdated terminology is also widespread, and many terms used in laws originate from colonial Britain. In many countries, the terms indecent acts is used to criminalise homosexuality, which can lead to survivors not coming forward when they've been abused by an offender of the same sex. Defilement can confuse the correct definition of rape and victimise female survivors, and child pornography or prostitution implies consent on the part of the child for their own exploitation. Outdated terminology such as this was found in 19 out of 21 countries. Another common issue in legislation is the tendency to exclude male survivors by referring only to female survivors or using other gendered language in law. In some countries, certain laws only apply to girls and therefore exclude boys and children of other gender identities from protection. This was the case in 13 countries that we studied. Turning to the issue of specific forms of abuse, we found that the trafficking of children is insufficiently addressed in many countries. We also found that only 11 countries studied had laws in place which were advanced enough to criminalise many forms of abuse, online and technology-facilitated abuse, including live streaming, grooming, and exposure to sexual content. 15 countries studied insufficiently criminalised child marriage, and FGM is explicitly illegal in only 6 of the 21 countries studied. The sexual exploitation of children in travel and tourism is also currently not adequately addressed. Extraterritorial jurisdiction means that governments can hold their citizens accountable for crimes committed abroad. And only 9 countries studied had extraterritorial jurisdiction over CSEA offences with no limiting factors in place. This leaves children outside of these countries vulnerable to abuse by travelling offenders.
Goodness. So the research has really shown that there are still significant gaps in laws throughout the Commonwealth. But finally, beyond legislation, what has the report highlighted that must change in order to better protect children against exploitation and abuse throughout the Commonwealth?
We found that legislative change alone is insufficient to counter CSEA. Countries often have comprehensive laws on the statute book, but implementation mechanisms are weak and laws are often not enforced or monitored. Limitations in policing were often cited as reasons for this, as a result of a lack of resources or insufficient training for the proper investigation and prosecution of these crimes. Police departments were often described as underskilled or incapable of gathering sufficient evidence to secure convictions. And additionally, many lack awareness and understanding of child sexual exploitation and abuse, particularly its online forms and CSAM. There are also lots of issues around the interaction with the criminal justice system, particularly for survivors. This results in low prosecution rates and dissatisfaction with the criminal justice system. Barriers can include the inaccessibility to formal justice for rural communities, limited resources available, and the economic burden of testifying in court. There's also widespread mistrust in the criminal justice system, which is influenced by the belief that the system is corrupt, negative police attitudes and treatment of survivors, family pressure, and delays and backlogs of court cases. We also found that only 9 of the countries that we studied implement child-friendly justice to limit the re-traumatization of survivors. Survivors often have to give testimony in the same room as the offender. Their identity is not protected in media reporting. They are not supported whilst giving evidence, and judges and prosecutors are often not trained to be sensitive to the needs of the child during the court process. There are also limitations in the child protection systems of many Commonwealth countries. Social services in 11 countries were found to be under-resourced and overburdened. In many countries, NGOs and civil society fill the gaps in providing support and services for survivors, but most are also underfunded and limited in their capacity. We found that very few countries have disaster preparedness policies in place which account for the particular vulnerability of children during disasters. Considering the susceptibility of many Commonwealth countries, including small island states, to climate-related disasters, and also the impact of the COVID-19 pandemic, this is concerning. Data is another common issue throughout the Commonwealth. Many countries urgently need to establish national data collection and dissemination, as well as monitoring mechanisms to inform and keep track of child protection. Finally, in many countries, more attention is needed on prevention. Awareness and education is key, and communities need to be engaged through awareness raising. Knowledge about CSEA remains low, both for professionals and citizens, despite evidence of programs to raise awareness being found in 17 of the 21 countries studied. Particularly, cultural and societal factors which increase children's vulnerability and stigmatize survivors need to be addressed. Thank you.
Thank you, Beth, and what an amazing achievement this report is. There is clearly a lot to be addressed, and I know that within the report there are country-specific and Commonwealth-wide recommendations for action that highlight the potential for learning and sharing amongst countries and regions. Now let's hear from our distinguished panel. Brian Speers, as President of the Commonwealth Lawyers Association, what is the role of the law throughout the Commonwealth in guaranteeing children's protection from exploitation and abuse and ensuring their access to justice, and what more can be done?
Well, thank you, Sarah. And I'm almost just recovering from the report that Beth has shared, in part enlightening, but in part harrowing as well to learn the information that is contained within the report. So can I offer congratulations to It's a Penalty for this launch and for the report. The CLA was very pleased to have played a small part in its involvement, which, as we have heard, has been as the result of the collaboration of many entities and parties. The CLA is an organisation of practitioner lawyers throughout the Commonwealth, and its council represents all of the 54 member states in the Commonwealth and other territories and jurisdictions as well. Its mission is to uphold and support and promote the rule of law. And the rule of law, as we hopefully know, is a foundation for a just and fair society. The issues around child exploitation and sexual abuse not only touch the heart personally, but go to the heart of the rule of law. If there are laws, they must be upheld. If there are no adequate or sufficient laws, then laws must be legislated for and enacted. And of course, no one is above the law. But in societies supporting the rule of law, you don't need new law to state that abusing a child is wrong and unlawful. It is doing harm to another. It is acting without consent. You may need laws, as we have heard, to convert treating children who are abused as offenders, but see them as victims. You may need areas of law, as Beth has identified, where the lawmakers can harmonise definitions of a child, can begin definitions for trafficking, and can arrange for cross-border or extraterritorial cooperation. There are other gaps, such as the online legislative gaps that we have learned about, and which Carolina has mentioned, and the fact that in some jurisdictions boys are excluded is clearly something that requires a legal change. Of particular concern is the fact that in having a law which is not enforced, that can create a culture of impunity. People are not caught through poor law enforcement, and people who are caught are not convicted through technical or evidential thresholds not being met, or communities not being able to provide evidence. The absence of resources to law enforcement and the absence of resource to supporting victims all reduce respect for the law and for the rule of law. While there are undoubted difficulties in applying law in communities who claim customary law or religious practice somehow justifies their activities, the CLA stands for law which is compliant with international standards and being implemented and applied and enforced. All the treaties and conventions, of which I'm sure we'll hear more of in this discussion, will count for nothing and will ring hollow if they are not applied and are not enforced. In the preface to the CLA report on child marriage, my predecessor wrote, it is trite to say that children are the future. They are indeed, but they are more than that. They are individuals in the present, with hopes and dreams and innocence, with boundless promise and potential, and importantly, with legal rights. It is those who have come before, including us, who have the privilege of being in professions of power and influence, who must ensure that rights are upheld and that potential is realized for all children everywhere. I hope that this report, this launch, will inform, inspire, motivate, and create awareness, but mostly will stimulate action to ensure that laws are enforced, laws are improved, and vulnerable children are protected to provide, as the Secretary General said, a safe Commonwealth for all of our children, and in particular to ensure that throughout our Commonwealth, the rule of law is respected and upheld. So congratulations once again, Sarah and It's a Penalty, and to all involved in your report. Thank you.
Thank you, Brian. We are honoured to have the partnership of the Commonwealth Lawyers Association. Next, I'm delighted to welcome Maria José Castello Branco, who is the Vice Chair of the Lanzarote Committee. Maria, can you tell us about what is the Lanzarote Convention, and then why and how could Commonwealth countries consider acceding to the Lanzarote Convention?
Thank you very much. Thank you very much, Sarah. It's a pleasure for being here, as I told you. And it's also an honor to be in this launching of the report, which was really amazing feature. So answering your question, what is the Lanzarote Convention? Lanzarote Convention, it's the nickname of Council of Europe Convention, which has a large name. It's on the protection of children against sexual exploitation and sexual abuse. It was signed in 2007 in Lanzarote, and that's the name we use often, the Lanzarote Convention. It's a very peculiar and yet extraordinary document. It has features that you cannot see often in other conventions because it has principles, definitions, measures, organizational rules, also substantive criminal law, which is based mainly on child-friendly justice rules, and also has a monitoring mechanism in order to evaluate if the countries, if the states are complying with the demands of this convention. It goes from prevention to support to prosecution, and in a common protective atmosphere that involves everyone in the society, from judges to social services, to educators, to families, to the cultural level, to non-government organization. Everybody, even children, are called to stop this. What would be a benefit of having this convention? The standards. The standards are essential. The sharing practices, building capacities activities, having or using the convention as a legal basis for legal assistance or in criminal matters or extradition, developing new methodologies as it can be with children participation. In our last monitoring round, which is related with self-generated sexual images or videos, we had 300 children saying what they thought about this problem. Mm. So it has a lot of possibilities. It's not only a criminal law convention, it's also education convention, a social affairs convention, a public service convention. Mm-hmm. So it's very, very complete. But let me tell you, just to close my intervention, that today we have 46 Council of Europe member states on this convention, plus Russia Federation and Tunisia. And this brings us to your question, Elizabeth. Yes, non-member states from the Council of Europe can accede to the convention. It's quite an easy process. And of course, we will be there to help whoever wants it. If you want to look at it, you can look into Article 46 of the Convention and also to the link that Elizabeth is going to provide you. So thank you again, and congratulations for the marvelous work you are doing. Thank you.
And thank you, Maria. And we really look forward to exploring the future of the Lanzarote Convention in the Commonwealth. On to our next panelist, and I'm delighted to welcome Fabakary Jammeh, who's the Practice Director at Sunu Law Chambers. Fabakary, as a practicing lawyer in the Gambia, West Africa, what are the key issues in preventing child sexual exploitation and abuse? And in your opinion, how can countries throughout Africa work together to improve child protection and address common issues?
Thank you very much. And it's a pleasure to be here to discuss this valuable topic. Generally, in the Gambia, children across the Gambia continue to be at risk of violence and harm due to deeply rooted traditional practices that normalizes female genital mutilation, children marriage, child labor, and corporal punishment. There has been statistics that at least 34% of young women in the Gambia are married before the age of 18 years, and 50% of girls between the ages of 0 to 14 have undergone female genital mutilation. The number of children subjected to child labor also remains very high at the moment. Although there has been some notable progress in some areas, especially, for example, in the enrollment of children in school, and also there, but there remains a serious issue in terms of their retention in school, because according to figures, 65% of children finish, 65% of children finish primary school, and out of these, only 45% reach senior secondary education. So these are some of the issues currently facing children in the Gambia, especially in terms of CSEA, that is, children sexual exploitation. So, and according to the World Bank, children in the Gambia achieve only 40% of their full potential, and this situation is mainly due to the high level of poverty, leading to inadequate access to basic educational services. Also, there are other issues that are also very, very critical to some of the issues preventing, the issues that are relevant to these issues. For example, we have violence against children, especially at the domestic level. Although there are laws that prohibits this type of actions and omissions, but these laws are not adequately enforced because of weak law enforcement and weak law enforcement institutions. And also there is an issue of inadequate reproductive health care and education, and we have discrimination against girls and also children born out of wedlock. These are also issues that are preventing the full realization of protecting children in the Gambia and elsewhere. And also there is a competing level of protection. For example, we have different sources of laws in the Gambia, which includes, for example, the Sharia law, that is Islamic law, and also the customary law, and also the common law and the law and the principles of equity. So there is an existence of different level of protection in all these sources of law. For example, the Sharia law what common law will regard as a child marriage will not be regarded as a child marriage under the Sharia law. And for example, the Sharia law would allow anybody that reaches puberty, irrespective of his or her age, to be able to get married. But while the common law, for example, would pick that for example, the Children's Act would say the age of getting married, or the age that child can get married, is 18 years of age. So these competing protections that are afforded to a child in the Gambia also makes it impossible and difficult to prevent abuses against children. So another factor, like I stated earlier, is the cultural norms. There are different cultures in the Gambia, and as I said, the customary law is part and parcel of Gambian laws. So these cultural laws also, they somehow accepted some forms of violence against children, and also some forms of labor that involves children. So these cultural norms are also making it difficult to be able to protect children in the Gambia and elsewhere.
Yeah.
So there are other issues such as trafficking of children. As you know, international organizations have documented, Gambia is a source and destination and transit for trafficking children, and this is in respect to the high level of tourist interactions in the Gambia, and because Gambia is a tourism destination, and Gambian economy at about 1/5 of Gambia's GDP depends on tourism. So this leaves children in a very unprotected space because of the prevalence of arrivals of tourists in the Gambia, and also the idea of trafficking children from other parts of West Africa, like Sierra Leone, Liberia, to the Gambia for the purpose of exploitation. So this also is an issue in the Gambia. This is also coupled with the law enforcement of laws in the tourism industrial areas, and also the weak institutions that existed in these areas in order to enforce these laws. So another issue that can also be connected to this is ignorance, because most of these laws in the Gambia are not, people are not very aware of these laws in the Gambia. So all these factors are issues that contribute, or that poses a challenge to the protection of children in the Gambia.
Yes.
So in West Africa, in my opinion, in order to be able to enforce these laws and to protect children from all forms of abuses, it is essential to enforce these laws, to prevent impunity, and also to ensure that children are also protected online, not only on physical spaces.
Yeah,
so without, I think this is some of the issues that are affecting the protection of children in Gambia and some other African countries. Thank you very much.
Thank you very much for sharing some of those statistics that are, really very concerning. But we really appreciate your perspective and highlighting the importance of working together in the region of Africa.
Thank you.
We're now going to Zambia, and we turn to Musenge Leah Nkonde, who's the associate at Mshiwi Banda and Associates. Musenge, looking ahead to the Commonwealth Heads of Government meeting, CHOGM, in Rwanda this June, what do you hope are the outcomes for children that are prioritized on the global stage?
Thank you, Sarah. To begin with, what we are hoping to see the heads of government discuss is firstly for them to look back, look at the declarations that have thus far been implemented in the Commonwealth with regard to protection of children's rights. There's been a number of very fantastic declarations. One comes to mind, the 2015 Kigali Declaration by the Commonwealth Forum of National Human Rights Institutions, which was on prevention and elimination of child early marriages, forced marriages. That was also affirmed by the heads of government meeting that same year. It would be nice for the heads of government to say how far have state members gone in implementation of such declaration, because it's one thing to have them on paper, it's another to actually implement. Another that I am very excited about is the Commonwealth Cyber Declaration of 2018. It was the member state declaring a commitment to tackle cybercrime. So in Zambia, I am very excited to say this, in 2021 last year, there was the Cyber Security and Cyber Crimes Act that was enacted. And it has some good provisions that protect children online. And we are happy about it. You know, for instance, child pornography, child solicitation have been criminalized specifically in that act. So if the heads of state could look at the declaration thus far made and see how far the member states have gone in implementing. Another thing that we would be happy to see from the meeting of the member states is a talk of a treaty. Maria has talked about the Lanzarote Convention, which is fantastic. And we have just learned today that non-European nations can accede to it. That should be something that the heads of government should discuss. You know, the beauty of having a holistic document that encompasses all issues of CSEA would be much better than just having declaration on child trafficking, child labor. Why not have this one treaty that covers and tackles all these issues? So if the heads of government would discuss that, we'll be very happy. And thank you, Maria, for that information. Another thing that we'd like to see, and tied to the treaty, a treaty that covers all issues regarding CSEA, is a joint effort by the heads of government to hold each other accountable. I mean, by that, I mean, you know, you look at which states are lagging behind in protection of children's rights and the why behind that. How can other states, member states help? You know, I'll give an example, and it's very sad. In Zambia, there's the draft children's code bill that has not even been presented before Parliament. Now, this is supposed to tackle most of the children's rights issues. And it was first mentioned in Parliament by the Minister then of Gender and Child Development in 2015. But up to now, it hasn't even been, it's not even a bill. It hasn't even been discussed by Parliament. And so you see, there's potential for good pieces of legislation to be enacted, but then why aren't we enacting them? So those are questions that the heads of government would do well to discuss, you know, at next month's meeting. And with that said, I'm just excited about this report because it's a step. I hope it's the first step in the right direction, you know, with many to come. And yeah, congratulations, and we're very happy to be a part of it. Thank you.
Thank you so much. And thank you for sharing those insights. And I couldn't agree with you more. I think, you know, a joint effort, holding each other accountable would make a significant difference as well. We are really looking forward to seeing the outcomes of CHOGM this June. Thank you. Now over to Asia, and I'm very happy to welcome Hasan Irfan Khan from the law firm Irfan in Pakistan. Hasan is also a council member of the Commonwealth Lawyers Association. Hasan, are you encouraged by any recent steps forward that your government has made in Pakistan, and what is still lacking?
Yes, thank you, Sarah. It's my pleasure to be here. I think I am generally encouraged, although I must admit that the issues of sexual exploitation of children is very much widespread. And we, as everybody has said, we need to do more than what really needs to be done. I think our governments have zero tolerance, and successive governments, our previous Prime Minister, our current Prime Minister, the government, as you know, Pakistan now, after the 18th Constitutional Amendment, has the provincial autonomy as well. So a lot of provinces have also legislated. Pakistan has passed a law which deals with National Commission on the Rights of Child, and there is a law, and it's a very high-powered body comprising of high-ranking officers, not below the rank of 20 grade, from Interior Ministry, Foreign Affairs, Human Rights, and they have recently also made some recommendations concerning the issues which were generally related to forced marriages, which are usually for people with different religion. For example, a Hindu girl is forcefully converted to Islam because under the Islamic law, they perhaps play more with the law on the age factor of the girls. So they made certain recommendations. I think in brief, I can say that we have a major issue, as we have issues with a lot of Commonwealth countries where different laws define the age of a child to be of marriageable age differently. Then we have a similar situation of Sharia law, where the puberty and the marriageable age is determined differently from the codified laws. a welcome thing in the recent past is a judgment from Islamabad High Court by Mr. Justice Babar Sattar, where he has examined all the laws and examining the constitutional guarantees of protection of child and women and also Islamic laws. He has held that the age of child is 18 years of age. So any child who is below the years of 18 of age will not be considered as an adult, because under different judgments, sometimes you could determine that if a person or a child or a girl has achieved a certain physical state, then they could be considered to have achieved puberty, and they could marry and they could give consent. So he has laid down the test that irrespective of the physical state of a child, the biological age will be the determining factor. So that's a very significant development and a very recent development that we have taken. We have in Pakistan. There have been certain reports going on where the issue, as has been highlighted, has been increased. Issues have increased during pandemic. According to one report, not only the girls are affected, but the boys are also affected. So the ratio is like 56 to 46%. So I would generally say that Pakistani government and Pakistani institutions, they have zero tolerance and they do whatever is necessary to curb this aspect. But other than legislation, as has been pointed out, we need to have more proactive and preventary measures adopted, not only in Pakistan, but I believe throughout the Commonwealth. So thank you very much indeed.
Thank you, Hasan, and that is so insightful. Finally, we're moving to the Caribbean and Americas, and I'm delighted to welcome Dr. Letnie F, who's a retired senior lecturer in social work at the University of the West Indies in Barbados. Letnie, from your research, what are the highest priority recommendations that governments should take forward in order to improve the protection of children from exploitation and abuse?
Thank you, Sarah. Caribbean governments are concerned about the prevalence of child abuse and neglect in the region. Some states have implemented legal reforms and increased social services and programs to tackle the problem. However, there's still much to be done, since outdated legislation with outdated terminology is still being used in many countries to protect children. Therefore, governments need to consider some of the high priority recommendations of this research to improve the protection of children from sexual exploitation and abuse. Mandated reporting is not part of the legislation of most countries in the region, and therefore, mandated reporting and the protection of mandated reporters, together with a central register of child sexual abuse offenders, need to be a central feature of child protection legislation across states as a matter of urgency. More importantly, there needs to be the reform of the current legislation that pertains to the protection of children from abuse in order to provide a better systemic response. In the case of Barbados, the harmonization of the child law system is long overdue. And according to two researchers, Jones and Trotman-Jemmett, reform and harmonization should entail the consolidation of all the relevant legislation provisions relating to children, amendment of those provisions which are inadequate, and the repeal of provisions that are not aligned with international standards. Now, there are several other legislative measures which need to be taken as a matter of priority to close some of the gaps that we know exist. This includes legislation outlining the measures to be taken in order to protect children from harm and abuse in terms of natural as well as man-made disasters, legislation that addresses the inconsistencies in the law in terms of the definition of a child, inconsistencies between the age of consent and the age of majority, and that standardizes the age of the child as under 18 to ensure protections for all children. We also need legislation that allows the use of DNA evidence to identify sex offenders, and that makes it mandatory for all victims of child sexual abuse to give evidence in camera, and that allows the use of video recorded statements to protect survivors of child sexual abuse against re-traumatization when given evidence or testifying in court. Governments also need to introduce legislation to protect children against online sexual exploitation, and that allows survivors of child sexual abuse over the age of 16 years to report and seek justice for the sex crimes committed against them when they were children. Caribbean states also need to keep their child protection legislation in line with the various international conventions, such as the Convention on the Rights of the Child, the Lanzarote Convention, the Budapest and Palermo Conventions. Additionally, decisive action should be taken to introduce measures to eliminate the backlogging in the justice system of cases of violence against women and girls, including cases of child sexual abuse, thereby urgently addressing the delays in prosecuting cases of child sexual abuse in the court system and providing timely justice. Specialized family courts to hear and determine all child-related matters, and the training of police officers and other professionals who work with children in the justice system to deal with child sexual abuse and human trafficking cases is indeed critical. Finally, Caribbean government should establish and publish a national cybercrime policy and dedicate resources to the various agencies and state organizations, and also resources to data collection and empirical research that can identify the multiplicity of factors that place children at risk for sexual exploitation and abuse in this day and age. Thank you for listening, and I've been pleased to be part of the project.
And thank you so much for those really important recommendations. So that concludes our panel, and I am now delighted to officially launch the CommonProtect report. You'll find the full report and executive summary and recommendations on It's a Penalty's website at itsapenalty.org/CommonProtect-report, or follow the link that is being shared in the comments of this live stream. So I am very grateful to all of our speakers and panelists who have shared their insights and recommendations during this live launch. Thank you as well to everyone who's joined us during this event, and to all of you who are watching. The full recording of this launch will be available on It's a Penalty social media, so you can rewatch and share it at any time. So to sum everything up, it's clear from the findings of the CommonProtect report and this panel discussion today that all Commonwealth countries can take further steps to better protect children from sexual exploitation and abuse, whether through legal reform, improved implementation and enforcement, more comprehensive and fully resourced child protection systems, or increased awareness and education. The joining of forces is key. We know that the Commonwealth can be an effective forum to prioritize and work together as a whole in order to address the protection of children. Throughout the Commonwealth, the governments, Commonwealth accredited organizations, law enforcement and criminal justice professionals, lawyers, civil society, parliamentarians, social workers, corporate stakeholders, and survivors all have a significant part to play. Together, we can build a Commonwealth where no child is vulnerable to sexual exploitation and abuse. Thank you.